Most people over 60 in this country have no idea they are one medical event away from losing access to everything they own, not because of fraud, not because of a scam, because of a legal system that was specifically designed to work this way, and the document sitting in your home safe right now, the one your solicitor told you would protect your family, is completely useless for exactly the situation you are most afraid of. I am going to prove that to you in the next few minutes, and then I am going to tell you what actually works. Before I do, drop a comment below and tell me what documents you currently have in place. Just a will or something more? I want to see how exposed this audience really is. Right, here is what is happening right now across England and Wales. 10,000 people are diagnosed with dementia every single month in the UK. The Court of Protection is processing tens of thousands of new applications every year, and the waiting times are running at 4 to 6 months for even a straightforward, uncontested case. That is for 6 months of frozen assets, mounting care costs, and a family standing outside their own financial life with their nose pressed against the glass. And the reason they are outside, the reason the money is locked, is almost always the same. The right paperwork was never done, not because the family was irresponsible, because nobody told them the paperwork they had was the wrong kind. Here is what that actually looks like in real life. A woman, call her Margaret, is 73. Her husband Robert is 75. He had a stroke 6 days ago. He is alive. He is in hospital. The neurologist used the word permanent when describing the cognitive damage. Robert does not know where he is. He does not recognize his wife. Margaret has bills. The recommended care facility charges £4,500 a month. The NHS will cover some of the immediate hospital costs, but continuing healthcare funding takes months to assess. The eligibility criteria are narrowly interpreted, and nobody in that hospital is promising her anything. She needs money now. So she does what any sensible, organized person would do. She finds Robert's last will and testament, the one signed and witnessed 3 years ago, and she drives to the bank. Robert has held his pension drawdown account at this branch for over 2 decades, £480,000, every penny they saved from selling the business in 2014. She walks in, she puts her driving license on the counter, she has the marriage certificate, the will, and a letter from the consultant. She tells the cashier she needs to access her husband's account to pay for his care. The cashier calls the manager calls compliance. The compliance officer comes out, sits down across from Margaret, and says 11 words she was not ready for. Your name is not on this account, we cannot help you. Margaret holds up the will. She is his wife, she has documentation, she has a letter from his doctor. The compliance officer explains, as gently as he can, that the will only has legal effect after Robert dies. Robert is alive, and because Margaret has just told them he is cognitively incapacitated, the bank now has a safeguarding obligation under FCA guidance and their own internal protocols to restrict access to that account. They cannot release a single pound to anyone, not a spouse, not a child, not anybody, until a court-appointed representative arrives with a valid order from the Court of Protection. Margaret walks out of that branch with nothing, £480,000 frozen, care bills ticking up every day, and a legal process ahead of her that will take months and cost thousands just to get back to where she was before she walked in. That is the incapacity trap, and it is the most expensive legal blind spot in British retirement planning. Smash the like button right now. Seriously, hit it. The legal industry in this country generates enormous revenue from Court of Protection cases and deputyship proceedings, and content that explains how this system actually works gets suppressed. Every like, every share, every comment pushes this in front of someone who still has time to act. So hit it, subscribe, and turn the notification bell on, because this channel is building a library of information that the retirement industry does not want you to have. Now here is the disclaimer I am legally required to say. This is not financial advice. This is not legal advice. It is a factual description of how a system works that will affect a significant percentage of the people watching this video, and nobody in a suit has bothered to explain it to them plainly. If you would prefer to pay £300 an hour to hear this from someone with framed certificates on the wall, that is entirely your choice, but understand that the same profession billing you for that advice is the same profession that benefits when you get it wrong. Right, the compliance officer was not the villain in Margaret's story. He was doing exactly what the law requires him to do, under FCA consumer duty rules, under UK finance safeguarding guidance, under the bank's own policies. The moment any institution has reasonable grounds to suspect cognitive impairment, they are legally obligated to restrict the account, not permitted to restrict it. Obligated, a spouse, a marriage certificate, a will, none of that overrides a Court of Protection order requirement once that flag is raised. The bank is not the problem. The problem is the architecture the legal system has built around elderly people's finances, and the single piece of paper that would have prevented all of this costs less than a family meal out. Let me show you the 3 layers of this trap, because if you only understand that a problem exists, you cannot protect yourself from it. The first layer is what I call the will illusion. This one has been sold to the British public for 60 years by every high street solicitor with a sign above their door: get a will and your family is protected. It is the most dangerous half-truth in personal finance, and it costs families tens of thousands of pounds every single year. A last will and testament does one thing: it distributes your assets after you are dead. That is the entirety of its legal function. It is a death document. It carries zero legal authority while you are breathing. None whatsoever. If you are alive but cognitively incapacitated, your will cannot authorize your spouse to pay a care home invoice. It cannot instruct a bank. It cannot access your eyes appareil. It cannot touch your pension. It cannot do anything at all until you are gone. At that point, it springs to life, not a day before. I have sat across from people managing 6- and 7-figure estates, former teachers, retired engineers, people who ran their own businesses for 30 years who told me they were sorted. They had a will, and I had to explain to them that a will with nothing else is not estate planning. It is a death plan, a very expensive, very useless death plan for the years their spouse might spend living with their incapacity. The second layer is the deputyship process. Once a bank account is frozen on incapacity grounds, the family has one legal route available to them. They apply to the Court of Protection for a deputyship order, specifically a property and financial affairs deputyship. This gives a named person, usually the spouse, legal authority to manage the incapacitated person's finances. Here is what that actually costs. A solicitor to prepare and file the application runs between £1,500 and £3,500 for a straightforward case. London firms charge considerably more. The court filing fee is £385. A capacity assessment from a qualified practitioner, which the court requires, costs between £500 and £1,500, total just to start the process roughly £3,000 to £6,000 minimum. Then you wait for 6 months on an uncontested application in current conditions. During that entire period, the frozen assets remain frozen. The care bills do not pause. The family pays out of their own pocket while Robert's £480,000 sits untouchable in an account Margaret has been paying into for 20 years. When the order finally comes through, the court does not simply step aside and let the family get on with it. It supervises. Every year, Margaret must file an annual report with the Office of the Public Guardian, a forensic breakdown of every financial transaction, every care expenditure, every decision made with Robert's money. The OPC supervision fee alone is currently £320 per year. Most families cannot produce these reports themselves. An accountant or specialist solicitor charges between £800 and £2,500 to prepare them. And here is the part that should make your blood run cold. The court orders the bank to release a portion of the frozen funds to cover the legal costs of the deputyship application. The court uses Robert's own money to pay for the legal process that decides whether Margaret is allowed to access Robert's money. Read that again slowly. Over 5 years, the total bill for this solicitor fees, court fees, assessment costs, annual OPGE fees, annual reporting costs, miscellaneous correspondence runs between £13,000 and £25,000. Conservative estimates, assuming no disputes, no complexity, no professional deputy involvement. In a contested case or in London, double it. Every penny of that comes out of Robert's estate, money he worked for, money they saved, gone. The third layer is the capacity deadline, and this is the one nobody ever mentions until it is too late. To sign a lasting power of attorney, the document that would have prevented everything I just described, you must have mental capacity. At the moment you sign it, under the Mental Capacity Act 2005, that means you must understand what you are signing, why you are signing it, and what the consequences are. You must be able to retain that information, weigh it up, and communicate your decision. If you have already crossed into moderate dementia, you cannot sign it. If your stroke has already affected your cognition beyond a certain point, you cannot sign it. The window has closed, and no amount of money, family pressure, or legal creativity reopens it. Once capacity is gone, the only available route is the Court of Protection. There is no alternative, there is no workaround, there is no exception. Now let me show you the maths, because this is where it stops being a story about Margaret and starts being a story about you. Robert is 75, he has a pension drawdown account worth £200,000, an ISA worth £150,000, £30,000 in a savings account, and a mortgage-free house worth £420,000. Everything in his name only. He has a will and nothing else. He has a stroke. His family applies for deputyship. Over 5 years, the total legal and administrative cost of running that deputyship, solicitor fees, court fees, OPC supervision, annual reporting comes to somewhere between £13,000 and £25,000. That is the cost of Margaret being allowed to spend Robert's own money on Robert's own care. Now run the same scenario with one difference. 3 years earlier, Robert spends one afternoon at a solicitor's office. He pays roughly £250 to £400 for a lasting power of attorney for property and financial affairs. He pays another £250 to £400 for the health and welfare LPA. He pays £82 each to register, both with the opt total outlay from start to finish somewhere between £700 and £1,000. Robert has the stroke. Margaret walks into the bank with the registered LPA. The bank looks it up on the OPC register. The compliance officer nods. The manager asks what she would like to do. Margaret goes home that evening with access to every account. No court, no judge, no annual report, no deputyship fees, no months of waiting. While the care home invoices pile up. Cost to the estate over 5 years, £800 of proactive legal work saves a minimum of £13,000 in reactive legal damage. That is not a financial return. That is the difference between a family that stays intact and a family that spends the worst 18 months of their lives navigating a court process while their parents' savings drain away. Send this video to one person today. 1. A parent, a sibling, a friend who you know has a will and thinks that is enough. Not because I am asking, because the day they need this information is the day they will not have time to find it. Now let me explain why the system is built this way, because understanding who benefits from your ignorance is the most important part of this conversation. There are 3 engines running the court of protection and deputyship machine. The first is the billable hour. Every solicitor involved in a deputyship, the family's solicitor, the capacity assessor, the professional deputy if one is appointed, the costs draftsman is paid by time, not by outcome, not by how well they serve the family, by time, 6 minutes, 12 minutes, 30 minutes, every letter, every phone call, every document review. The longer the case runs, the more complex the family situation, the more dispute there is, the more everyone gets paid. A grieving, panicked family fighting over the care of an incapacitated parent is not a tragedy to this system, it is a revenue stream. The second engine is annual supervision. Unlike a lasting power of attorney, which is a one-time registration, a deputyship order creates an ongoing financial relationship between the family and the court. Annual reports, annual fees, annual oversight, year after year, for as long as the person remains incapacitated, which in a dementia case could mean a decade or more of compulsory annual billing. The third engine is professional deputies. In some cases, particularly where families are in dispute, or where the court decides the family member is not suitable, the court appoints a professional deputy, usually a solicitor. These professional deputies charge between £150 and £250 per hour to manage the financial affairs of someone they have never met, using money that belongs to someone else's family. This is not rare, it is routine, and there is no obvious mechanism by which the family can remove a professional deputy once the court has decided to appoint one. All 3 of these engines stop the moment someone has a valid, registered, lasting power of attorney in place, which is precisely why so many families have spent years being told by people in suits that a will is probably sufficient for their situation. That was never advice, that was pipeline management. Right. For accounts you need to shield right now, while you still have full capacity, save this section, write it down, because the day you need this checklist is the day you will be too overwhelmed to look it up. Your pension, whether that is a drawdown arrangement, a SIP, a final salary scheme you have already moved into payment, or a workplace pension, is almost certainly your largest single asset. Access to it during your lifetime is controlled entirely by the scheme administrator or platform, and without a registered LPA naming a trusted person, that access is frozen the moment the institution has any reason to question your capacity. What you need to do: register a property and financial affairs LPA, submit the registered document directly to your pension provider, not to a filing cabinet, to the actual provider, and check your expression of wishes. That is the nomination form telling the pension trustees where you want your pot to go on death. It is not legally binding, but trustees give it significant weight, and an outdated nomination can cause enormous problems. Check it, update it. Your ISAs, investment accounts, and any unit trusts or investment bonds sit in the same category for lifetime access purposes. The registered LPA is your mechanism for giving a trusted person authority to manage these. If you cannot, submit it to every platform. Do not assume they will cross-reference each other. Submit it individually. Confirm receipt and keep a copy of every confirmation. Your current account and savings accounts. This is where the most basic, most preventable mistake happens at scale. Older couples who have managed perfectly well for 40 years with accounts in one spouse's name suddenly discover, on the worst day of their lives, that the other spouse cannot touch the money. The fix is straightforward. Add your spouse as a joint account holder, on a genuine joint account with full access rights. Neither party can be locked out by the other's incapacity, and for any account you keep in a sole name, submit the registered LPA to the bank proactively before you ever need it. Many banks have a process for preloading this. Use it. Your property. For most families in this country, the house is the largest asset on the balance sheet, and it is the one that creates the most catastrophic freezes when things go wrong. If your home is in your name only, your spouse cannot sell it, remortgage it, or access equity release against it without a deputyship order, not for any reason, even to fund your own care, even if selling is the only financially sensible option. There are two practical solutions for most families. Joint ownership as joint tenants with right of survivorship means both names are on the title and the surviving partner inherits automatically on death. But joint tenancy alone does not solve the lifetime incapacity problem for transactions like a sale or remortgage. You still need the LPA for that. So the second solution is the one that actually closes the gap. Register a property and financial affairs LPA and ensure it explicitly covers property transactions. The LPA, once registered with the OPG and presented to the land registry and any relevant solicitors, gives your appointed attorney legal authority to deal with your home if you cannot. For more complex situations, blended families, large property portfolios, inheritance tax planning, care funding concerns, a trust structure may add an additional layer that requires a solicitor who specializes in this area. Get proper advice for your specific situation. Beyond the four accounts, there are three documents that work alongside the Property and Financial Affairs LPA. The Health and Welfare LPA is a separate document covering medical and care decisions: where you live, what treatment you receive, whether life-sustaining treatment continues. Without it, the medical team dealing with Robert has no legal obligation to involve Margaret in those decisions. They will make best interests decisions under the Mental Capacity Act, which may or may not reflect what Robert would have wanted. An advance decision to refuse treatment sets out specific treatments you refuse if you cannot communicate your wishes at the time. This is legally binding in England and Wales when properly drafted. Without it, the default is that clinicians make the call. And your healthcare provider's GP, hospital, care home will refuse to discuss your condition with your family unless they have a signed LPA naming them, or a separate written consent document. Data protection law gives them an easy reason to stonewall anyone who turns up without the right paperwork. A registered health and welfare LPA removes that barrier completely. Here is the sequence of what you actually need to do. This week, contact a solicitor who specializes specifically in lasting powers of attorney and estate planning. Not a general practice firm, a specialist. The Society of Trust and Estate Practitioners maintains a directory. The Law Society's website has a search function. Find someone who does this work every day, not someone who does it occasionally alongside conveyancing. Within 30 days, get both LPA's Property and Financial Affairs and Health and Welfare drafted, signed, certified, and submitted to the OPG for registration. The registration fee is currently £82 per document. Budget an additional £500 to £800 in solicitor fees for a standard case. Total cost under £1,000. Once the registered documents come back from the OPG, which currently takes between 10 and 20 weeks, which is another reason not to wait, deliver certified copies to every institution holding your assets, your bank, your pension provider, your ESA platform, everyone. Do not file them at home and assume someone will find them. When they are needed, review every account ownership structure, joint accounts where appropriate, beneficiary nominations current, expression of wishes updated. Anything in a sole name with no LPA registered against it is a risk. And then do the single most important thing, which costs nothing. Tell your family, tell them the documents exist, tell them where to find them, tell them who the attorney is, because on the day the stroke happens, on the day the consultant uses the word incapacitated in a corridor, the people who love you are going to be in shock. They are not going to be systematically searching through filing cabinets. Make it easy for them. The capacity window. This is the part I want to end on. There is no warning sign. Dementia does not announce itself with a firm date. Strokes do not give you advance notice. Cognitive decline moves slowly and invisibly for months or years, and by the time anyone in the family is concerned enough to have the conversation, the legal window to act may already have narrowed to almost nothing. By the time mild cognitive impairment appears in a medical chart, some people are already in territory where a capacity assessment for LPA signing becomes uncertain. Not everyone, but some. And there is no way to know in advance which category you fall into until the assessment is done, and by then you may not be able to act on the result. Every month you put this off is a month where the window is a fraction narrower than it was. That is not a scare tactic, it is the law. So here is what I want you to do when this video ends, 2 things only. First, have the conversation today with whoever needs to hear it, your spouse, your adult children, your closest family member. The sentence is simple. If something happens to my brain, who do I want managing my money, and have we actually written that down anywhere? That conversation has never been easier to start than right now. Second, get on the phone to an estate planning solicitor this week and get a consultation on the calendar. Most firms are running for 6 weeks out right now. The older population in this country is enormous and growing, and the demand for this kind of planning is accelerating. Every week you wait is a week further back in the queue. Subscribe, turn the notifications on, because this channel is building an archive of information for people who refuse to let the Court of Protection, the OP, a bank compliance officer, or a professional deputy they have never met dictate what happens during the worst period of their family's life. This is not about fear. It is about the fact that the paperwork that protects your family costs less than £1,000, takes a few months to process, and sits in a safe doing nothing until the day it does everything. The paperwork that does not protect your family, the will in the manila envelope, costs less too, but on the day it matters, it is worth less than the envelope it came in. Register the LPA, both of them, update the nominations, sort the accounts, have the conversation, and do not wait for a better time, because the better time was 3 years ago and the next best time is today. I will see you in the next video.